So, a very warm welcome to Campion Hall, Oxford, for the penultimate of the Father Martin Darcy S.J. Memorial Lectures 2021, which are being offered by Campion Hall together with Georgetown University Press. My name is Father Nick Austin. I'm the Master of Campion Hall, and we're very glad to have you here with us, whether you're here in Oxford or elsewhere. This week's lecture I'm very much looking forward to. I'm a moral theologian whose work has focused especially on Thomas Aquinas, and this week's lecture by Dr. Patrick Riordan is entitled Politics and Law, the Limits of Bounded Rationality, and he'll be focusing especially on Thomas Aquinas. A reminder to you to post your questions in the Q&A section at any time, and we'll have a chance to engage with some of those questions towards the end of our hour together. Patrick, over to you.
Thank you, Nick. Over the course of these Darcy lectures, there have been many responses and challenges, some communicated via the Q&A, others per email, and still others in the conversations here in Campion Hall. In this lecture, I hope to respond to some, at least, of those questions by clarifying limits also of our rational capacities, as well as disciplinary limits in law and in politics. I will begin by noting the key questions. In the second section, I will present and comment on key texts from Aquinas on law and the common good. Third, with the benefit of insights, one from a reading of Aquinas, I will outline answers to the questions and draw out some implications. This work should clear the ground for next week's final lecture, in which I will apply some of these tools to topics of integral ecology and humane economy. Many have found it confusing that I talk about common goods in the plural and the common good in the singular, sometimes with an emphasis on the, as if intending to imply its singularity, its uniqueness. So they ask, what is the relationship between a common good, common goods, and the common good? A related question arises from the many kinds of things that are said to be common goods. For instance, in the lecture on politics and conflict, lecture 4, I spoke of the institutions for handling conflict, such as courts and parliaments, as common goods. But also the persons who build, maintain, and operate those institutions are spoken of as common goods, as are their skills and competencies. And the culture of shared values and meaning that sustains all of this can also be included in the listing of common goods. How can that be meaningful, to use the same term and apply it to so many different kinds of things, different phenomena? A third question is posed by some who expect that there should be something normative about the talk of common goods. Don't we have obligations to provide for and care for the common good? Where do these obligations come from? They say to me, don't you want to say something about duties? It seems wrong somehow to suggest that some people are into the common good and devote their lives to it. Other people aren't interested in the common good, but that's okay. They don't have to do anything about it. Surely it can't be right to say it doesn't matter whether or not we care for the common good. And if we do have duties and responsibilities, where do they come from? How are they grounded? In this short lecture, I will attempt to answer these questions. I begin by taking a text from Aquinas to find some resources for this task. A classic text for the notion of common good for St. Thomas is his set of questions about law from the Summa of Theology, the first part of the second part, questions 90 to 97. I want to highlight 4 points: Aquinas' intellectualism, the complexity of the material, the different disciplines involved, and the use of analogy. I will concentrate on this last one and so mention the other 3 briefly for the sake of completeness. In question 90, inquiring into the essence of law, Aquinas breaks it down into 4 aspects, asking whether law pertains to reason, what is the purpose of law, what is the source of law, and the role of promulgation. This discussion builds up a complex understanding of law that Aquinas can compress into a definition. He says, it is nothing else than an ordinance of reason for the common good, made by him who has care of the community and promulgated. He explicitly calls this a definition. That law is a matter of reason requires that subjects of the law must have an intelligent grasp of the connection between what the law says it is good to do and what would constitute the well-being and flourishing of the community. The renowned Thomist scholar Brian Tierney sees in Aquinas' discussion a rejoinder to something cited from the jurist and encapsulated in what Tierney calls the apparently absolutist principle of Roman law. The will of the prince has the force of law. Tierney maintains that Aquinas concedes the point about the prince's will, but only under the condition that his will is in accord with reason. The primacy given to the role of reason over the command of the ruler is the intellectualism of Aquinas stressed here. Reason grasps what is good. There is an intellectual comprehension of what is suitable or appropriate for achieving the intended good. And this lends the directive force to the rules and laws that are made. The contrast with a focus on the notion of command, rooted in the will of the ruler, is explicit in Aquinas. He does not deny the element of will and of command, also in the case of the individual agent, but these follow from a grasp of the appropriateness of what is commanded. In the second of the 4 articles in his question on the essence of law, Aquinas asks if law is always for the common good. The inclusion of the mention of the common good in the eventual definition quoted might be quickly glossed over unless one follows the discussion with care and notes Thomas's firm association of law with the common good. It is always for the common good. Aquinas' answer will not be persuasive for many readers today, since the reasons he gives rely on contestable assumptions. Aquinas presents 2 arguments in the body of the article. The first relies on the Aristotelian teleological conception of an ultimate end. Practical reason is by its nature oriented to an ultimate end. And following Aristotle, who in his Ethics named this eudaimonia, Aquinas calls it felicitas vel beatitudo, felicity or beatitude. The second argument relies on the relationship of parts to the whole. The parts of any complex structure are oriented to the whole, and the good functioning of any part contributes to the well-being of the whole. As human individuals are parts of a complete community, he maintains, the law which directs action towards their good must consider the shared well-being of all involved. Both arguments are likely to be challenged. On the first one, there are those like Hobbes or many contemporary liberals who deny that there is a summum bonum, an ultimate end, which is the common good of all reasonable beings. On the arguments about parts and wholes, there can be a double challenge. The first is more fundamental, inquiring if the individual human being is properly understood as a part of something else. The characteristic of wholeness belongs to the autonomous individual person. The second challenge might concede the point borrowed from Aristotle about understanding the members of a political community as parts of a whole, but deny that the analogy applies to the relationship between individuals and humankind. The human population of the world today is not a complete community in Aristotle's sense, nor is the human species over time. And yet, that would have to be the presupposition on the basis of which the natural law might be defended in these terms as being for the common good. After all, Thomas's thesis is that all law is for the common good of the relevant community. In Aquinas' defense, it is important to recall that his work is a compendium of theology, and that he can assume that the relationship between creator and creation and creatures has been clarified in earlier discussions. Relevant points that we don't have time to go into here in detail are: 1, the dependence by participation of all that is in the pure act of being, which is the divinity. 2, the ultimate goodness of the creator, whose desire to share being, truth, and goodness is at the heart of the will to create. 3, the creator's providential direction of all creation, and especially humankind, to an ultimate destiny. 4, and that as goodness itself, God is the final cause of human beings and their actions. These theological premises can provide filling for the apparent gaps in the argument that might otherwise seem to be problematic for a purely philosophical reading of his text. Here we see the complexity of what Aquinas writes. Taken out of context, it might appear to be a standard discussion of law within a philosophical horizon, but attention to the context reminds us that it is part of a theological treatise. This is my third point, the importance of theology for understanding the account of law. And now to the point about analogy. Aquinas relates 4 terms in his account of law. 1, there is a community. 2, it has a common good. 3, there is some body or somebody with care for the community. Let's call it the authority. 4, there is law as a reasonable directive. Promulgation could be a 5th term, but I leave that aside for the present. In discussing the various kinds of law in question 91, Aquinas notes that there are 4 kinds, and that for each of these kinds of law, there are the same 4 terms. This does not generate 16 elements as we might at first expect, since there is overlap. The 4 kinds of law are eternal law, divine law, natural law, and human law. Corresponding to eternal law is the whole community of created being that is governed by divine providence, divine reason, which orders all things to their end. Aquinas can refer back to his discussion of creation and divine providence when he considers this example of law, so he doesn't need to elaborate in great detail. However, it may strike the reader that his use of the notion of promulgation in relation to eternal law is problematic. Aquinas notes that promulgation is made, he says, by word of mouth or in writing, and in both the divine word and the writing of the book of life are eternal. The divine word is the second person of the Trinity, through whom all things were made, as we are told in John's Gospel. The word proceeds from the Father, who is the source of the wisdom that is cause of all that is. This theme carries over to the second article concerning natural law, which Aquinas understands as reason in human persons, by which one can know what is good to be done and evil to be avoided. Here too, promulgation is by creation, in this case, specifically of beings of a rational nature. Human-made law is intimately linked by Aquinas to natural law, even to the point where he will say that law, to be valid, must be in harmony with the natural law. It is not always so by deduction or derivation, but in many cases by determination, whereby authorities specify some manner in which goods are to be secured and protected from harm, it being important that all affected be aware of the appropriate directive. For instance, drive on the left. A point frequently overlooked by readers of Aquinas is that he understands legal validity to bind the consciences of addressees. He makes this an explicit question, whether human law binds in conscience. If the criteria for just law are met, then they are binding. Those criteria include the law's purpose, its author, and its form. Unjust laws that are opposed to human good or to the divine good are not binding in conscience. Let's look briefly at the implications of this position for the relationship between law and common good. The community of humankind among whom the natural law, human reason, is promulgated has a common good, which is presumably the natural fulfillment, happiness, and beatitude of persons and their groups. Such fulfillment includes the actualization of the cardinal virtues of justice, prudence, fortitude, and temperance. Human-made law, which is always addressed to a specific community, intends the common good or fulfillment of that community and its members. Human-made law is binding in conscience to the extent it is in conformity with the natural law, and presumably the intended common good of human-made law, when just, also includes virtue and virtuous actions. But now we have a hesitation on Aquinas' part. He explicitly excludes that human-made law should attempt to command acts of all the virtues, and he also rules out that human-made law should attempt to prohibit all vices and vicious acts. In giving his reasons, we find him using a conception of common good of human communities that is less than or more restricted than the comprehensive common good of humanity, whether we think of that as natural or supernatural. Let us attend to his reasoning and use of the notion of common good. I quote from question 96, Article 2. Human law is framed for a number of human beings, the majority of whom are not perfect in virtue. Wherefore, human laws do not forbid all vices from which the virtuous abstain, but only the more grievous vices from which it is possible for the majority to abstain, and chiefly those that are to the hurt of others, without the prohibition of which human society could not be maintained. Thus, human law prohibits murder, theft, and such like. Note here the very constrained focus of concern. We have to prevent evil acts, but not all possible evil actions. There are some actions which, if tolerated, would make social life impossible, such as murder and theft. Murder and theft are Aquinas' examples, but societies in history have considered others. For instance, giving false witness in a court, perjury, or blasphemy, corrupting the youth, treason, adultery, voter fraud. Deliberations among lawmakers would be different from those envisaged by Aristotle, whose main concern would be the moral character of citizens to be formed by the normed practices in the city. We noted that in the earliest lectures. Thomas's civil lawmakers would have as their principal but not exclusive focus, the viability of the city, the maintenance of human society. Note in particular the filter he uses. Which evil acts are principally to the hurt of others? The word translated as hurt here could just as easily be harm. And then we would have a resonance with John Stuart Mill's discussion of the grounds for restricting liberty. It's always worth drawing attention to Mill's formulations in his essay on liberty, which he misdescribes as a simple principle with a single end. In fact, his ends are twofold: society's protection of itself and prevention of harm to others. Note how Aquinas, in his formulation, combines these two purposes. Certain acts that harm others are to be prohibited, because if tolerated, social life would be impossible. In Aquinas' discussion, there is something of a constriction of focus, what I call an accordion effect of more and less in regarding the common goods of overlapping communities. The common good of a particular city, its survival and maintenance, is a means to the more extensive common good of humankind, especially as revealed in divine law. Such a common good is certainly not a sufficient means, since the kind of regime that tolerates some vices and some evil actions is not identical with one that ambitions the moral fulfillment of every person and the whole person. The distinction between necessary means and sufficient means for the ultimate, unrestricted common good is vital here. Note how this accordion-like changing of perspectives is invoked again in the treatment of human law's relation to virtues. Concern for virtue in total is not the principal concern of human lawmakers, but again what Aquinas will treat as the limited common good of a specific society. He writes, again, this is a rather long quotation, "Human law does not prescribe concerning all the acts of every virtue, but only in regard to those that are ordained to the common good." Speaking here of the common good of the human community, a city, either immediately, as when certain things are done directly for the common good, or mediately, as when a lawgiver prescribes certain things pertaining to good training, whereby the citizens are disciplined in the upholding of the common good of justice and peace. The common good in question here cannot be that unrestricted common good which is the end of both natural and divine law. Human law is concerned with a more confined purpose, and two possibilities are envisaged. For instance, for the sake of its common good, a republican regime following Rousseau might make the exercise of public duty obligatory. For instance, make it obligatory to vote, to serve on juries, and so on, since these are directly for the common good. At the same time, indirectly fostering the common good, the republican regime might require the attainment of literacy and familiarity with the civic order as objectives of educational policy. Thomas acknowledged the possibility that human-made law might be unjust and so not binding in conscience. But as many who mocked his thought through the centuries have pointed out, the dismissal of an unjust law as no law because not binding in conscience does not let you off the hook when brought before the magistrate. Recall his listing of cases of unjust law. Law that is contrary to divine law is clear enough, commanding, for instance, child sacrifice or worship of idols. But human-made law can fail to be just on three scores: the end of the law, the author of the law, and the form of the law. Thomas says, in respect of the end, as when an authority imposes on his subjects burdensome laws conducive not to the common good, but rather to his own cupidity, greed, or vainglory. Hard for us today to imagine a politician who is motivated by vainglory. Or in respect of the author, as when a man makes a law that goes beyond the power committed to him. Or in respect of the form, as when burdens are imposed unequally on the community, although with a view to the common good. The like are acts of violence rather than laws, Thomas concludes. So these three defects of law, we recognize, we have phrases for these. Cui bono, so to whose good is the law directed. Ultra vires is the lawmaker acting beyond the powers given to them. And inequity in the way the law affects different groups of people, different persons. For the sake of completion, I mentioned very briefly the divine law, which refers to the law promulgated by Moses and Jesus, contained in the Torah and the Gospels, namely the Ten Commandments, the Decalogue, and the commandments of love, the new law. Surveying the four kinds of law and the four terms, it is clear that Aquinas is operating with analogical understandings of the terms. The authority, the one with care of the community, can be the creator, the God of revelation, or human civil powers. The relevant community can be the whole created order, the community of creatures, or it can be humankind enjoying the power of reason, or it can be a political community in some time and place, or it can be the people of God bound by covenant, whether the old or the new. These are very different communities with different laws, differently promulgated. Similarly, with the notion of common good, the end of the relevant community, we find analogy in play. The good is the end, that at which all things aim, and in each case, the community has its own end, its completion or fulfillment. In the case of the law of a human society, its common good is an end, but at the same time, it is instrumental to a more ultimate end. The fulfillment of the created order is difficult to specify or reconstruct, while the beatitude of life in the resurrection with Christ, though mysterious, at least has the particularity of Christ's promise. The fulfillment of humanity is that it should flourish in achieving excellence in the activities appropriate to it, as Aristotle would say, but those activities and the corresponding excellence are revised by Christian revelation to a transcendent end and a graced existence. What then is the end or common good of civil community? If those charged with care of the community must formulate and promulgate directives of reason oriented to the common good, then they must have some idea of what that good is. What is it? How do they know it? As Aquinas ranges over the different kinds of law, applying his 4 terms in the different cases, we note his facility in using terms with varying meanings, although within a range. A community of creatures is different from a community of rational beings, which is different again from a community of faith or a localized political community. In fact, in any one place such as Oxford, to take a convenient example, all 4 kinds of community overlap, but they do not coincide with one another. To use the term community of all 4 requires a facility in analogy, not equivocation, since the variation in meaning is not arbitrary, but is within a range from a core meaning or central case. Similarly with the other notions of law, authority, and common goods. So, having looked at Aquinas, is it possible to return to our opening questions and see if adequate answers can be found? Remember the 3 questions. What is the common good? Is it both singular and plural, and how are these related? Second, if it is many kinds of things, what is their common factor warranting the same label? And third, is there some normativity about common goods? And if so, where does it come from? I dare to formulate the judgment that there is only one instance of a unique singular referent for the term, the common good. That instance is when we speak of God, or cognate terms such as life in God, the beatific vision, the resurrection, when we speak of these as the common good. God as final cause is that which ultimately all creatures desire, and is goodness itself, in which all created goods participate. All other references to the common good as singular require a restriction of horizon, so that accordion effect again, whether explicitly or implicitly. We see this occurring when Aquinas writes of the common good of a particular society. He brackets out, for the sake of clarity of focus, any consideration of more ultimate common goods, or indeed more restricted common goods, such as those of households that are members of the political entity. So this is what is meant by bounded rationality in the title of this lecture. Our reasoning is confined within boundaries, and we do it best when we acknowledge the relevant operative limits. Note the accordion effect in the following set of questions. What is the common good of Campion Hall? What is the common good of the Faculty of Theology and Religion? What is the common good of the University of Oxford? What is the common good of the British higher education system? What is the common good of the United Kingdom? And so on and so on. Recall, wherever people cooperate, and they do at all these levels, they cooperate for a good in common, especially in education, in academia, in teaching and research. Those cooperating will put some effort into specifying their purpose, that for the sake of which they build and operate the relevant institutions, and gather the communities of teachers and students, researchers, administrators, benefactors and beneficiaries, patrons and clients. They will publish mission statements, record their histories, and highlight their values revealed in continuity with the past. But no matter how well the formulations are fashioned, there will always be a question whether the espoused values are coincident with the operative values. Truth might appear as a key value, but one might find oneself or one's colleagues economical with the truth when the interests of benefactors or of civil and ecclesiastical authorities are jeopardized. Besides, the implication of a neat nesting of the levels listed above like Russian dolls may be deceptive, as when the values espoused by the theological faculty are found to be disruptive of the university's growth agenda. In my 2015 book on global ethics and global common goods, I attempted to illustrate the complexity of the flourishing of a complex organization, such as a university or a modern city, by listing all the aspects or dimensions of common goods involved. I found I could distinguish 11 different levels. The most counterintuitive of the levels of common goods are those of shared meaning, shared understandings that are either or both the precondition for acting together or that which we attempt to strengthen, reinforce, or expand by our cooperation. In the latest issue of the Heathrow Journal, I've published a survey of recent literature on a wide range of common goods that again illustrates the analogical nature of talk of common good. So the second set of questions has to do with what is common to all of these great variety of phenomena. This question seeks the one among the many, the common factor that makes it meaningful to apply the term so widely. I return to Aristotle for this. Whoever acts, acts for some good. Whoever cooperates, acts for a good in common, a common good. Good is what is the end of action, what is desired. Common is applicable when the good is the end of cooperation. Analogy illustrates how this can be applied in so many different ways, but meaningfully, without always ending in contradiction or equivocation. It might be useful at this point to use some examples to clarify cases where common good is not appropriately used. We are familiar with the term commons, especially as made current by the expression, the tragedy of the commons. There are natural commons and human-made commons. Natural commons include climate, the atmosphere, the seas and oceans, and with qualification, what we call natural resources. There are cultural commons that give us the term, such as Port Meadow here in Oxford, shared grazing land in the river's floodplain. Other examples of human-made commons are the condition of war or of peace, of health risk due to infections or pandemics. Commons can be good or bad. Goodness and badness I specify in terms of fostering or impeding human life and human activity. Our present pandemic situation is a bad commons, since it poses a threat to human life and limitations on human activity. The climate is also a commons. Some climates are inhospitable to human life, such as those at North and South Pole or in some deserts. Human life or activity cannot be conducted there without major cultural adaptation. A good commons becomes a common good when it is the object of human attention, valuing, leading to care, maintenance, or repair. A health environment without smallpox is a commons that has been the product of large-scale human cooperation. The elimination of malaria attempts to realize a similar commons and so is a common good. A related notion is that of public goods. Many people schooled in economics assume that when we speak about common goods, we are really talking about public goods. Economics distinguishes public, private, and club goods, as well as recognizing commons, what economists used to call free goods. These categories of goods are constructed in economic terms, considering the cost of providing the goods and the distribution of the goods to beneficiaries. Public goods, street lighting, national security are typical examples. Public goods are non-excludable and non-rivalrous. Once they are in place, no one can be excluded from benefiting from them. And the addition of extra beneficiaries does not diminish the share of those already enjoying the goods. Think of 10 people standing under a lamp pole enjoying the light it gives. The addition of 5 more doesn't diminish the share of each of them. At the other end of the spectrum are private goods that are both excludable and rivalrous. In between on the spectrum are club goods, goods shared only among members of the club, and so excludable, but up to a point are not rivalrous, such as a golf course enjoyed by the members of a golf club. Technology can change the economic nature of some goods, as when free-to-air broadcasting became subject to pay as you watch. Famously, public goods exhibit what is known as market failure, since they cannot be provided by the market. No entrepreneur will undertake the costs where there is no possibility of recouping the investment. Once the good is in place, no one can be excluded from enjoying it. The language of common goods comes from Aristotelian practical philosophy, not economics. And the relationship between cost bearers and beneficiaries is not the focus. All kinds of goods, whether public, club, or private, can be the intended goods of cooperation, and so be common goods. Common goods of persons who cooperate in order to bring them about. Some authors limit the category of common good unnecessarily and claim Aristotle's authority for doing so. In considering public health provision as a common good, for instance, we can read the following. Something qualifies as a common good if it serves the interests of all in a given community, universality, serves those interests in a uniform way for each person, uniformity, and does so in a non-rivalrous manner. That is, the serving of anyone's interests is not at the expense of serving any others, so non-rivalrousness. Such an understanding of common good is valid, but I object to the restriction of the term to such cases of public goods. It is perfectly consistent with Aristotle's use that people would cooperate to provide private goods for themselves, or even club goods. The golf course is a common good of the golf club members. A similar restriction is evident in John Rawls's definition of the term in A Theory of Justice from 1971, where he says, "The common good I think of as certain general conditions that are in an appropriate sense equally to everyone's advantage." This is a valid meaning, but unhelpful if used to exclude other meanings. The common good of a family, for instance, is not equally to every member's advantage. And to the third question about normativity. Several people have understood the invoking of common goods to entail a prescription, something that ought to be pursued, something that should be done. Normativity here linked with notions like ought, should, duty, obligation. But they say they miss from my discussion any grounding of common goods in normativity. The texts from Aquinas cited above did recognize elements of normativity in the notion of command from the will of the ruler. I suggest, however, that the principal examples are about those subject to the discipline of laws, people described by Aquinas as wicked or immature, unable to see the point of the law, and needing the additional motivation of threat of punishment. This situation was also part of our consideration when reflecting on the topic of paternalism and the permissibility of prescribing the good for others, that they have not or not yet chosen for themselves. Insofar as we have access to goods and to goods in common, they have their own attractiveness that can motivate action in their pursuit. Corresponding to those various types of goods are what Aquinas calls inclinations in people. The desire to live, to partner and reproduce, to have friends, to bond in society, to know, to discover what is good. These are naturally present in people, and it is superfluous to command them to live, to be healthy, to mate, to seek knowledge. They have libido, drive enough to command themselves. In his section on the natural law, Aquinas mentions, but hardly spells out, these inclinations. One point that might be relevant to the present question is how to interpret what he identifies as the first principle of practical reason. Some have translated it as a command, do good, avoid evil. Others see it as elaborating what is meant by the notions of good and evil, because preceding the statement of the fundamental principle was a statement of the meaning of good, namely, that it is what all things seek after. The Dominican translation of the first precept is that good is to be sought and done, evil to be avoided. The need to prohibit some vicious actions is because of the threat they pose to social existence. Thomas mentioned what could not be tolerated. He also saw the link between these necessary prohibitions and the prohibitions of the Ten Commandments. What is necessary and helpful is the negative injunction to avoid evil, to desist from harm, to take precautions against unwanted consequences of our actions. What is the rationale of such prohibitions? Alistair MacIntyre defends natural law by speculating on the conditions that would have to be upheld in a reasonable encounter between people espousing different ethical theories claiming rational validity. He argues that such discourse will not be possible unless participants treat as binding upon them a set of rules that turn out to be just those enjoined by the natural law. The precepts in question are Aquinas' fundamental practical principle that the good is to be done and pursued, that the human goods to be pursued and not to be harmed are the goods of survival, of life, of knowledge, and social order. Acknowledging that the pursuit of truth in the context of disagreement is precarious, the open and self-critical engagement with others must presuppose a trust that one will not be attacked, robbed, lied to, or otherwise taken advantage of. These expectations, when articulated as precepts, are identified as preconditions for rational inquiry, and so are not known as a result of inquiry. MacIntyre's conditions for rational inquiry are, like Aquinas' precepts, universal in scope, exceptionless, the same for everyone. He concludes that theoretical arguments cannot provide justification for these precepts, but can attempt to show that they are presupposed by rational inquiry, and that any practical inquiry which does not presuppose them fails in rationality. This final point is another endorsement of the intellectualism in Aquinas' approach, a standpoint I share. Next week, the final lecture in this series, we will consider some fraught issues today: integral ecology and humane economy as common goods. Thank you.
Thank you very much, Patrick, for that very interesting exploration of politics and law and the common good, especially through the lens of some of Aquinas' thinking. So I invite participants to continue to post your questions into the Q&A. Perhaps I can begin with a question. You stress the importance of recognizing the theological context of what Aquinas says about the law. And I'd certainly agree with you that the fullest reading of Aquinas on law is always going to be a theological one. But then that poses a question about the role of theology today in a secular or pluralist context when talking about common goods. Do you see a positive role for theology even in a context in which there's a plurality of faiths and of none. What would you answer to that?
Well, I think the answer is yes, that theology does have a place. I think that if you buy into my argument, you accept that there is this accordion effect, that we have the possibility of restricting our focus or expanding our focus to the most unrestricted dimensions possible. Now, if we follow Aquinas's argument and then it is also the argument that's made in Gaudium et Spes from the Vatican Council, that the common good of our political communities is that set of means and conditions that enable individuals and groups to flourish, to achieve their fulfillment. That is something that I think can be endorsed by people from very different backgrounds, different religions, and different philosophical commitments. But of course, they won't all agree on what is the ultimate fulfillment and the ultimate end of human life. But they still can come to agreement on what are the means and conditions that can be established, such as the ones mentioned in some of the texts there, such as peace and justice and good social order. From within the political community, from within the discourse about establishing peace and justice and good order, there can always arise the questions about to what end? What is the purpose ultimately? And there it is important that the political authorities not claim for themselves powers that they are not entitled to. As I pointed out previously, say in discussing political Augustinianism, I do not want to live under a regime that tells me how I am to worship, what I am to believe, what is my ultimate end. It is not the purpose of the political authorities to do that. But if they can function with the recognition of the limits that are appropriate to them, that there are more ultimate questions that they don't have answers to, but that it is valid for the liberal political community to allow those questions to be pursued in appropriate fora, not in the parliament, but in the university, in debating societies, in the press, in publications, and so on. People can pursue those more ultimate questions and can be facilitated in pursuing them. But it is important then that the political authorities recognize the limits to their own power and jurisdiction, situating the common good that they serve within a bigger, wider horizon that is beyond their competence.
Okay, thank you for that answer. We have one question here from Francis O'Donovan. Francis asked, should one stay silent on injustices even if one has been unwittingly a part of those injustices? Or should one speak out to ensure that the law is upheld? What would Aristotle say?
That's a very difficult question to answer in the abstract. I think it would be very important to know what are the concrete circumstances we're dealing with here. Maybe I can just make a few remarks about this notion of speaking out. I think there is a real danger of thinking that we achieve something simply by speaking out. A letter to the Guardian, I've spoken out, but what has that achieved? What has that changed? If I complain down the pub to my mates and speak out against what the county council is doing, I've spoken out, but have I changed anything? I think we have to be very political and intelligent, practically intelligent in seeing where do I devote my energies? What are the issues that I can make a difference to, where I can affect some change, and then find where I can collaborate with others equally concerned, and we can get something done perhaps by mobilizing, by conscientizing others. Again, going back to an earlier lecture where I made that theme, made that a point. But speaking out is not always helpful, it's not always effective, and it can be counterproductive. One thinks of Chairman Mao's Cultural Revolution when he said, let 1,000 flowers bloom, or 1,000,000 flowers bloom, however many. And by finding out who were the people who spoke out, he was able to identify who were his opponents and got rid of them, annihilated them. So one has to be very, very prudent in finding what will be effective, what will help.
Okay, thank you. So one other question I'd like to pose, especially in light of your distinction between the commons and the common good. Perhaps this touches on the theme of next week's lecture a little bit, but in Laudato Si, Pope Francis, if I remember correctly, says that the climate is a common good. Is that technically accurate in your terms? And what does common good thinking have to contribute to this question of shared responsibility in response to the climate crisis?
Yes, I take the point. I think, you know, it's important when reading an encyclical or any church document that one interprets it and makes some effort to understand what is really intended here and what is meant. I don't think that formulation from Pope Francis is intended literally as a generalization, such that all climate is a common good. What he is referring to is the way in which, where we do succeed in making a decent life for ourselves, we are taking for granted elements from the natural environment, such as the climate, such as the earth itself, resources such as air and water. These are elements that are part of the commons that we take for granted, that sustain our existence, and without which we wouldn't be able to make a life and feed ourselves and house and clothe ourselves. So he draws attention to this common home that nourishes us and nurtures us, and then says, look how we are dependent on it, and look how it is endangered by the way we've mistreated it. So let us take care of it. So then what is intended to as a commons is to become a common good, because a focus of our attention to care for, to stop harming, to repair harm that may have been done already where we can. But it is the orientation to the common action, I think, that makes our commons into a common good. One might say, however, that, you know, drawing attention to the way in which it is already a precondition for common action is linking the commons of a climate or air and atmosphere and water and so on, links that to action already, drawing our attention to it so that we recognize how much it is a precondition for what the good it is that we want to achieve. So then part of your question was to ask about obligation, and I think the force of the Pope's argument is not to say, do what you're told, you ought to do something to care for the earth. He's not just saying you have a duty to do this. He's saying, look at how important this is as what nourishes us, as what houses us and makes it possible for us to have a decent human existence, and see how it is endangered. And once you've grasped those connections, once you've seen the intelligibility of the good and the means to achieving the good and the threats to the good, once you've grasped those relations, you can see what it is you are obliged to do about it. So it is the comprehension of the real that leads to action, to seeing what one can do and what one is in a position, perhaps uniquely in a position to do, that one is then obliged to do.
Okay, thank you. Another question I might ask, my particular interest is in virtue, and you said some things about the relationship between the law and virtue, especially in response to Aristotle's famous statement that the law's purpose is to make people good. What about politics more generally? I mean, does politics have a care for the education of character, the education of people in the good? In education at the moment, for example, there's a lot of emphasis, certainly in a British context, on character education, for example. Is that a sort of welcome move, or is that overstepping the bounds of what politics should really be about?
Yes, thank you. I think when maybe it was the second lecture when I was noting the question about Aristotle. How can Aristotle be relevant to politics today? And Aristotle, with a very high moral understanding of the role of legislation, the lawmaker, having a concern for the character of citizens. Does the law today have a purpose of making people good? And there I relied on a distinction from Aquinas that I haven't mentioned in today's lecture, but a good opportunity to mention it now, where Aquinas says, yes, it is the purpose of the civil lawmaker, the civil authorities, to make people good, but we have to distinguish the different senses of good. There is the more ultimate fulfillment, the completion, which is achieved, we will want to say in Christian faith, it's achieved by God's grace. And it is also without the harms and limitations that arise from sin, from wrongdoing. So that's good in an unrestricted sense. But there's a more limited sense of goodness, which is that good is in a qualified sense, and the qualified sense is in conformity with, conforming with the law. So the civil lawmaker cannot look into men's hearts, to quote Queen Elizabeth I. The civil lawmaker cannot look into people's hearts to find out from what motivation, with what love of the good they are acting. The issue is, do they abide by the law or not? And it is sufficient for the human lawmaker that people are good to that extent that they comply with the law's requirements. Now, the point of the question, though, is to say, can the civil lawmaker today be content with simply people abiding by the law? Do we not need much more than that? And certainly, people in the Republican tradition will challenge the liberal tradition on this point, to say, where are you going to get the citizens that are capable of acting with the rationality and the reasonableness that you require of your citizens, say in participating in voting and in jury service and in deliberations about public order policies and so on? Where are you going to get the characters who will be capable of doing that unless you devote attention to it? And therefore, it is quite appropriate that a political community would say, we must ensure that our citizens and the people who become our bureaucrats and administrators are trained to a level at which they have bought into the goods that are at stake in the political community, peace and justice and social order, and that they are motivated because of their regard for those things to act well. So very definitely, formation of character, the development of civic virtue has to be a concern of the political community. But political community understood here in the widest sense. I think there is a need for legislators, for the bodies that we call the parliaments and councils, to recognize the essential work that is done by families, by parents, by local community, and all of that work in forming the next generation or future generations, it cannot be dictated from above. It can't be manipulated from above. So the civil authorities have to have a care for those dimensions of human formation, of character formation and character building, that they will facilitate and protect, but they cannot dictate and make happen because it's beyond their power. The real danger, as we know, is that misguided directives from above or misguided rules and arrangements can thwart a lot of what is really genuine good education, character formation, Bildung in the German sense. And so we have to be careful that we make our politicians aware of the risks that they run in harming goods that are already present in civil society and civil society bodies and in families, that they have an obligation not to harm, but rather to facilitate. But good. Yes, to character formation.
Yeah, I suspect you wouldn't object to using the word subsidiarity.
Oh, thank you for that. Here. Oh, very definitely. Yes, I want to endorse that.
Good, excellent. Well, thank you so much, Patrick, for that very engaging and stimulating lecture and discussion. So thank you, and thank you to everyone who's joined us today, both on behalf of Campion Hall and our partners, Georgetown University Press. Please remember to join us for next week's lecture, which is the final lecture in the Darcy Lectures 2021, entitled Fraught Issues Today, Integral Ecology and Humane Economy. Thank you, and a good day to everyone.
Thank you.